Record keeping is critical to business because there's potential for businesses to be fined significant amounts if they don't comply with record keeping requirements under employment law. Businesses, whether you're in the federal or the state industrial relations system, there are regulations around the types of records that you need to keep for your employees, right from the start of their employment all the way through to termination or resignation. These can include things like what they've been paid, how much leave they've accrued, the superannuation contributions that have been made, the basis of employment, for example, full-time, part-time or casual, and a range of other things. For businesses in the state industrial relations system, record keeping obligations are regulated by the Minimum Conditions of Employment Act and to a smaller extent the Industrial Relations Act. The Minimum Conditions of Employment Act requires that businesses keep certain employment records relating to each individual employee, and these include things like the full name of the employee, their date of birth if they're under 21 years of age, gross and net amounts that have been paid to the employee, the date which the employment commenced, deductions that have been made to employees' pay and the reasons for them. Can also include things like leave accruals and when leave is taken, details on how to calculate long service leave, and the total hours worked if the person is earning less than $45,000 per annum. In addition, the Minimum Conditions of Employment Act requires that these records are kept in a particular format, so they need to be legible and they need to be stored electronically and easily available and able to be produced should a relevant person wish to inspect them. Records need to be made within 14 days of payment to an employee, and they need to be kept for a certain period of time. If it's a record relating to long service leave, then it's necessary to keep those records for not less than 7 years during the person's employment. And for all other records, it needs to be kept for 7 years after the record has been made. A relevant person when it comes to accessing records in the state industrial relations system includes the employee to whom they relate, but it can also include a person that has been authorised in writing by the employee to whom the records relate. So a representative of the employee, for example, they might be a member of a union and they might appoint in writing a union delegate to represent them. They would be an authorised person. It can also include an inspector from Department of Commerce seeking to audit whether the person has been paid correctly, for example, and they may wish to see those records. Under the state system, there's a number of fines that can be incurred for failure to make and keep records, and also for hindering or obstructing a relevant person in accessing those records. The State Industrial Magistrates Court can impose a penalty of up to $5,000 for an employer or a company who breaches this part of the legislation. In the state system, it can be the $5,000 fine can be incurred by the individual, so it can be someone who runs the business, owns the business, a director, for example, or it can be a $5,000 fine for the company itself as a body corporate. Businesses will either be in the national or the state industrial relations system, and there's different legislation that requires records to be kept under each system. And they do differ quite significantly. So it's critical that businesses first understand which industrial relations system they fall within before they can determine what records they need to keep. National system employers are businesses that usually are incorporated under the Corporations Act that will have proprietary limited or incorporated after their name and be a trading foreign or financial corporation. Usually sole traders and partnerships and some trusts will sit within the state system. When we're talking about record-keeping obligations under the national system, there's a requirement to keep records in accordance with the regulations contained in the Fair Work Act, and they are quite comprehensive. There are general records that need to be kept on file. There's records specifically that need to go on to employees' pay slips, and there's rules around how long they need to be kept and when pay slips, for example, need to be issued to employees. For example, under the national system, employers are required to keep records for 7 years from the time that they're made. Pay slips need to be issued within 1 working day of payment to the employee, and they need to be in a format that is easily accessible and as prescribed by the regulations. They need to be in English and they need to be legible. National system employers that fail to meet record-keeping requirements under the Fair Work Act have the potential to risk on-the-spot infringement notices being issued by Fair Work Ombudsman inspectors. So a Fair Work inspector can come out and audit the records, and they can issue fines of up to $540 for an individual. So your director or your company owner, for example, might incur a $540 infringement notice, or the business can incur infringement notices on the spot of up to $2,700. That's separate and distinct from Fair Work referring these matters to the courts, who can then go on to issue much more significant fines to businesses. If a matter goes before the courts, potentially a business could face up to $27,000 in fines per breach of record-keeping obligations, and an individual can incur fines of up to $5,400. Recent cases of businesses failing to meet record-keeping obligations, particularly in the national system, have seen some quite significant fines being issued. And in some cases they match or exceed the underpayments, which usually have resulted as well from the failure to keep records. For example, a recent case earlier this year where a business underpaid its staff around $30,000, and in addition to that, they failed to meet most of the record-keeping requirements contained under the Act, and failed to meet the pay frequency as well. So the fine of nearly $30,000 resulted from those breaches. Another recent case, which happened in June, where a business who was a travel agent had legal action taken against them for significant underpayments, and again, as part of the audit, it was found that they hadn't made or kept the correct records, and they hadn't issued any pay slips to staff, and where they had on the odd occasion issued pay slips, it wasn't done within the day, the 1 working day of payment. In that particular case, because it was so widespread across a large number of employees and over a lengthy period of time, the fine was quite significant. So that business was fined $228,500, where the underpayment was only $16,500. But it demonstrates the magnitude of the breaches involved, and there were multiple breaches in that particular case. And one other case which happened only a month or so ago, where a business had legal action taken against them. This was a restaurant owner who was fined $142,000, where they had underpaid staff around $12,000, but again, as part of that, hadn't met their record-keeping obligations or issued pay slips to staff. So CCI can assist businesses in a range of ways to ensure that they meet their record-keeping obligations. First and foremost, our Employee Relations Advice Centre team can provide businesses with over-the-phone advice and support to ensure that they are complying with those obligations. We also have a number of guides, HR forms and templates that can assist businesses in making sure that they are meeting those obligations. Additionally, we can come out and assist you by undertaking an audit for your business and then providing recommendations and support you in making changes that will allow you to be compliant.